This short podcast is about trusts of land and the role that equity plays in Hong Kong land law. As you know from your study of equity and trusts, equity was the system of rules originally developed by the English Courts of Chancery and that was adopted as part of the Hong Kong legal system. The role of equity within the Hong Kong system is to moderate the harshness of the common law, and it typically does this by preventing people from insisting upon their strict common law rights, where reliance on these strict legal position would be unconscionable. In Hong Kong land law, there are basically two broad ways in which a trust of land might arise. First of all, it could arise through an express trust, and that is where somebody who owns land transfers the title to the land to a trustee who agrees to hold the land on behalf of a beneficiary. So if I wanted to give land to my son, but my son's only 3, so it wouldn't be sensible to transfer ownership to him outright, I could find somebody who was prepared to act as trustee, and I could transfer the ownership of the land to that trustee, but the trustee would own the land on the understanding that it wasn't his, but that he was to exercise his powers of ownership on behalf of my son, the beneficiary. The other type of trust that we'll come across is the informal trust, and this is one where there's no express declaration of trust, and broadly speaking we are concerned either with resulting trusts or constructive trusts, and I'll explain these concepts later in the course. The most common area in which this arises is in the family home, where, for example, the ownership of the home, the legal title to the home, is vested in one partner, let's say the husband, but it's agreed that he'll hold the land on behalf of himself and his wife. And quite often in these cases, equity will find that the husband is the trustee on behalf of himself and his wife under the terms of that type of informal trust known as a constructive trust. Whenever you have either an express trust or an informal trust, the net result is that the trustee owns the property as far as the common law is concerned, but equity expects the trustee to look after the property on behalf of the beneficiary. The net result, therefore, is that ownership of the land has been split up into the legal and the equitable titles. The trustee is the legal owner, the owner of the land as far as common law is concerned, while equity views the beneficiary as having an ownership interest in the land. We've seen then that an equitable interest in land can arise either because there's an express trust, or because there's some type of informal trust, or thirdly, possibly an example of the informal trust, because there's been a contract to create or transfer an interest in land which is valid and enforceable, but doesn't comply with the formalities for the creation or transfer of an interest in land required by the common law or by statute. In the cases we've just mentioned, where there's an equitable interest in land, what we're saying is that there's both a legal interest in land and also an equitable interest in land at the same time. Now, the law on priorities is the important reason for the distinction between legal and equitable interests in land, and I'll explain that in the next slide. Let's imagine that there's a contract under which Larry has agreed to grant Teresa a 6-year lease. This contract is enforceable, it's binding, and so it creates an equitable interest in land. What we're going to assume is that the arrangement between Larry and Teresa doesn't take the form of a deed. The importance of this is that there's therefore no lease as far as common law is concerned, since the common law will only recognise the existence of a lease where it's been created by deed. So Teresa has got an equitable lease, but not a legal lease. She's got a lease that will be recognised as a lease by the courts of equity, but not by common law. The rule is that a legal interest is good against the whole world. That is, if Teresa has a legal lease, then anybody who later acquires an interest in the same piece of land takes it subject to Teresa's legal lease. The rule for equitable interests in land, like Teresa's equitable lease, is that they're good against the whole world, except as against equity's darling. Equity's darling is a bona fide, that's good faith, purchaser for value of a legal interest in land who has no notice of the pre-existing equitable interest. So Teresa's equitable lease is binding on everybody except for equity's darling. And that idea is explained by the next slide. Let's assume that Larry, Teresa's landlord, assigns his ownership in the land to Polly. And the question is whether Polly is subject to Teresa's lease, whether she has to acknowledge the existence of Teresa's lease, whether she has to allow Teresa to stay in the property. Now, if Teresa is equity's darling, if she's a good faith purchaser for value of a legal interest in land without notice of Teresa's equitable lease, then she takes the land free of Teresa's lease. She doesn't have to acknowledge Teresa's right to remain in the property under the terms of the lease. The trust is the most significant contribution that equity makes to land law, but we're also going to see during this course some other ways in which equity influences Hong Kong land law, and I've listed them in this slide. The law on specific performance, part performance, proprietary estoppel, the law on the enforceability of restrictive covenants, and the equity of redemption. I'm not going to explain them in this short podcast. They are explained in the seminar guide and in the longer podcasts.